Like your dog, Mr. Townsend.
Good morning.
Good
Oh,
morning, Your Honors.
Morning.
Okay, Ms. Lena, you're up.
May it please the court, Angela Liner on behalf of the appellant, Kimberly Martin, now known as Kimberly Jack, the former wife in the underlying proceeding. I'd like to reserve 5 minutes for rebuttal. We're here on the trial court's amendment or modification of a final judgment nearly 3 years after that final judgment was entered, without a supplemental pleading, without a proper motion for rehearing or appeal of the original final judgment. Basically, equitable distribution was modified.
And Ms. Liner, let me see if I could kind of zero in. Isn't basically the crux of this case is whether the change to the judgment constitutes the correction of a clerical oversight or a substantial change involving a mistake in the judicial judgment? Isn't that the bottom line, the issue facing us right now?
Mostly that's where the issues lie, but more importantly, I think for the court to consider and think about is it wasn't just something that was as simple as a clerical error. This wasn't a property address that was put in wrong. It's not that the address should have been 100 and instead the judgment says 10.
And I appreciate that that's your position, but how do you, and help me out, how do you reconcile the substance of the final judgment, making very specific findings of, I guess, lack of better word, fraud on behalf of the former wife, with the term use and possession? I mean, obviously, if you look at that final judgment as a whole, there's a disconnect there. Don't you agree?
Well, I don't really agree, because if it was this in court, if it was the trial court's intent, the original trial judge's intent to award a property to the former husband solely as a result of some sort of egregious misconduct or something along those lines, there are statutory requirements that would have had to been put into the judgment with very specific findings. And the court did not make any of those findings that would explain or justify any such unequal distribution at that time.
But didn't the judge also, though, in the final judgment, basically did not find the wife credible, went through very specifically some of the things that she has done in terms of alleging that that was a signature of a notary, where the court found that that was not the case? I mean, that was pretty damning type of, language in the final judgment. And so that's the question that I have, is that very clearly it appears that the final judgment intended on giving title to the former husband. And why is that not simply a clerical mistake, which is like either a omission or something within and under the rule, the family rule of 12.150?
Well, if it were simply a clerical mistake, here's the issue that is an important one for the court to understand. We're not just talking about one property that was part of this alleged error. There was a property with no allegations, no findings, no evidence presented at the time of trial, or specific findings raised in the judgment that said that former wife shouldn't have had another property, or there was some question or anything like that. But the issue—
Go ahead, Ms. Liner.
Well, just really briefly with that is just that it was not, there was other property too. So it's not just the singular property that had questions raised, but regardless, if it was the court's intent to say that deed was fraudulent, say anything of that nature, there's still not that sort of finding to reverse the deed effectively, which was the relief that was really sought by presenting all that testimony at the time of the trial. there wasn't any of that language included in the judgment. So it just went through all these findings about credibility, but then ultimately said, okay, we're dividing the properties.
Well, as I read I don't think you can, if you read this final judgment, I don't think you can conclude other than these two properties were the separate properties of the spouses. That the alleged transfer of them was from the sole title to joint was fraudulent, and the change here seemed to me to be like unnecessary. The court left the property in the ownership of the two parties, and purported to award them exclusive use, but it didn't find that they were marital properties. It seemed to find just the opposite.
I would dispute that a little bit with regard to it actually referred to the one parcel as the marital residence. An important factual,
that doesn't mean it was marital property.
but here's the important detail, is that the marital residence also included a marital dwelling that was put on the property during the course of the marriage. And the judgment doesn't separately distribute that property. And why that's important is if we were talking about a fixed brick and mortar home, that would have presumably gone with the property. However, we were not talking about a fixed brick and mortar home. We were talking about, I believe it's a triple wide, but a modular home that has titles that weren't retired, aren't affixed as part of the deed, and it didn't do anything with regard to the adjudication of what should occur with those. So the intent with the equitable distribution was to simply say this parcel's husband's, this parcel's wife's, and everyone moves on. Then we're lacking the distribution of a marital asset. That was
indeed, and your side could have asked for a rehearing or appealed on that basis, correct?
Correct. And just so it's clear for the record, we did move for rehearing. It was denied by the trial judge. We moved to vacate the judgment on the basis of these assets that were not distributed. That was denied by the trial judge, or well, a subsequent trial judge, not the judge who ultimately heard.
It was a senior judge, correct?
Correct. But it also, just so the court's clear, it was not the judge who ultimately ruled on this motion either.
Right,
it was the predecessor judge to the division.
Right.
But
So did your side appeal the denial of the motions, post-judgment motions, motion to vacate and so forth?
we did not, and here is why. Because ultimately, at the end of the day, the parties then held the properties in joint names. They were tenants by the in common, and they each had ownership, interest, and rights. Though the husband had exclusive use of one and the wife had exclusive use of the other, ultimately, that was the effectuation of the equitable distribution.
What do you make of the suggestion that the question of how title was held or how ownership was held was actually left sort of ambiguous by this final judgment?
I don't agree that's the case, and I'm going to cite to a long-held precedent by the Florida Supreme Court in the Davis case. We've held for more than 35 years, if a court does not expressly distribute the ownership interest, and in the Davis case, the wife had been awarded possession of the home, but the court did not adjudicate the ownership interest. And despite numerous attempts of trying to modify that post-judgment, the Florida Supreme Court said no. The bottom line is, if the court could have adjudicated that at the time of the final judgment, and they chose not to do it for whatever reason, and it wasn't done, the property is now held by tenants in common by operation of law, just the conversion from tenants by the entirety to tenants in common upon the dissolution.
It assumes, though, that these deeds to the parties as tenants by the entirety were good, and every finding in the final judgment suggests otherwise.
It raises credibility issues, but I don't recall, and I don't see any factual finding that expressly asserts that the deeds themselves were fraudulent, should have been vacated, should have been dissolved, or even the express finding that this parcel was wholly former husbands and there was no marital interest, because regardless, even if, for argument's sake, even if the court had found it was initially former husband's parcel, the wife had still asserted, and the court did not address the marital contribution with the home that I'd already talked about. And I think that's a very,
This was not a brick and mortar home. So is the triple wide, is that improvement to real property, or is that registered like as a mobile home, like a vehicle?
well, this one, as far as I was last aware, the titles were not retired to be part of the property. I'm not sure if the former husband has taken any subsequent action, but I can tell you at the time of the hearing it.
Triple wide is personalty, not realty.
Correct. Correct. It's the best case scenario is you retire the titles and you affix it to the parcel, but it in and of itself could still be as a separate item. But regardless, that was part of the parcel that wasn't distributed. And in my experience and from my understanding of how this should have worked, if that was the intent to treat that trailer as a separate item, it should have been adjudicated as such. It should have been.
And it's interesting, Ms. Lang, because here we have a very unique factual scenario where the actual presiding judge that prepared that final judgment testified. And so if you look at, let's look at for family rule procedure 12.540. And basically, very clearly, it says clerical mistakes in judgments or other parts of the record arising from oversight or omission may be corrected at any time on its own initiative or by any party. And here you segue, and if you look at the actual hearing where you have the actual presiding judge testifying and stating, this was a mistake. I needed to say title as opposed to use of possession. So how do this is what's before us right now, where you have someone saying this was a mistake, clearly mistake, was unrebutted. There was no contrary evidence provided. Why can't we just simply accept that and agree with the trial court below to affirm what he has done?
Well, the very important issue is that Judge Wilhite had the opportunity to correct her error if it was an error. There was a motion for rehearing. Simply, if she thought there was a question, she could have herself requested a hearing on that, amended the judgment at that point, because she clearly had to look at the judgment to determine.
And I appreciate that, but this rule doesn't say it has to be done within a reasonable time or it has to be done within it. There's no time limitation on this. So this rule basically contemplates that, hey, it could be, and right now we were up to 3 years later.
And here's where I think we can, and again, it's very fact specific and very nuanced case, but the issue is the trial judge on her own didn't take such actions. When they were pointed out to her, she ignored to take any action, in fact, declined to take any action. And even when asked at the hearing, independent of whether it was error or not to allow her to testify, she still acknowledged that she had no independent recollection of anything with this case. And well, even as
it's not exactly accurate. She said that she did remember this case.
No, that's what Mr. Townsend says. But then when I asked the question,
right.
if she remembered the case prior to being contacted by Mr. Townsend, and she said no. And it's later in the record because the court effectively denied my request of voir dire the witness prior to her testimony, and says that let me ask the questions on cross. And she did not have independent recollection. She did not recall the motion for rehearing. She didn't remember the parties. And I think that's a very key.
She remembered the case. She said that this should have said title rather than occupancy.
Well, she said that's more of a what she should have done, but she didn't expressly state anything that she remembered. And she even testified that she did not remember the parties. And if there was such a factual concern of credibility of a party or anything of that nature, she would have or should have remembered that. And it's more of a, what she stated was a what she should have done, not what she didn't do, not why she did something different in this case, in these circumstances. And that's a key distinction, because even if we go back to one parcel was marital to the husband, even if we take that fact as true, or I'm sorry, premarital to the
Yeah.
husband, even if we take that fact as true, if the court's intent was simply to equitably divide the parcels, and those are the words that are used in the judgment, then that wouldn't have even been an equitable remedy, because then wife got one property solely without the husband then being awarded any marital interest and an equitable distribution, because his non-marital property, if for argument's sake it was non-marital and it shouldn't have been considered, then the court should have addressed the equitable distribution with regard to the other property with either a finding of unequal distribution and laying out the statutory requirements of unequal distribution.
Well, I get that, but so aren't you making an argument here, Ms. Liner, about the credibility of this evidence versus the fact of the evidence?
Of
This judgment, is lacking in a number of ways, but that doesn't alter the fact that, the issue presented by, I guess, was this judge, I don't recall which judge this was below, but was whether there was
It was Judge Moody.
Judge Moody, whether there was an error in this judgment that was, correctable under 12.540.
And I would assert, and shockingly, there's not the case law that I thought would be on this issue with regard to what counts as a clerical mistake when we're changing
Yeah.
the title. But the one case that I could find on point was Keller out of the 3rd DCA that said, if you're changing title, ownership, that's not a simple clerical mistake. That's not just a oopsie. I believe the word they used was slip, but
I understand that. And I understand that this case, is sort of on the line between a purely clerical and a more substantive change. But if the judge was of the view when she entered this judgment that the title was ownership was in the respective parties, not joint, then using the word title was not a change of substantive change. It was a correction of a misstatement.
But that is the issue with regard to the second parcel. The Bullfrog parcel was clearly in joint names. There was no dispute as to any deeds executed related to it. And that parcel was held in joint names. So by operation of law, so that was what the court's intent had been to do, then again, we're still back to this one parcel that maybe there's a question, maybe the court found that it really shouldn't have been in joint names, but regardless, we have another parcel that has no such dispute, no such questions, and the court does not choose to take any action to adjudicate ownership of that parcel. And that's what's important, because that parcel, the court would have had to adjudicate, because then we are back to this question of equitable.
But Ms. Liner, that wasn't before the court. That wasn't brought up. I mean, you would have, if it was brought up before, but that's not what we're dealing with here. We're dealing here was simply to follow what Judge Northcutt said, is that if the court had intended, and we have testimony from the trial court, which is again rare, to say, this is what I meant to do, that's the concern.
But, and I would say that if we had a judge that remembered and really remembered the parties and remembered the case and remembered the evidence, and that judge said, yes, this is 100% what I meant to do in this case, not what I think I would have done. And that's just it. If we had a,
But that's not, but if you look at the transcript, that's not what the judge testified. At the beginning, maybe right before, said before Mr. Townsend reached, she didn't remember, but then she very unequivocally indicates she does recall this is exactly what she wanted to do. So I read it differently. I think it was pretty straightforward as to her testimony. Her testimony seemed to be very clear as to what her intent was, and basically acknowledging that it was a mistake.
and if that truly had been her intent,
Well, help me
that's,
out. We look at the transcript, we're reading at the same sentence. Where is there? Show me where in this transcript that indicate that this was not her intent.
by her denial of the motion for rehearing on these very issues before.
No, ma'am. I'm talking about at the transcript, at the testimony. I'm not talking about before. I'm talking about this one here. Where is it? We have an evidentiary showing with testimony. Where in her testimony did she say that her intent was different from what she testified to?
And it's not there because but that's the important thing. She did not remember factually all the details. So it's not in the transcript. It is not in the transcript. I will concede
right,
it's not in the
all right.
transcript.
It's Ms. Planner, you are in to your rebuttal time.
I will yield to my rebuttal time and I will reserve.
That works. Okay, Mr. Townsend, you're up.
I'm afraid to say anything for fear of overcoming what the court has expressed. I'm being facetious, but honestly, I think it's obvious what the court intended. And she did not participate in a re-evaluation, which may have required a different type of approach under the rules. And I just think it's obvious what happened here, and that the court ought to uphold the change. That's what the court originally intended, and there's no reason not to affirm.
Now let me and point out, and you guys correct me if I'm wrong, but as I look at the order that we have on appeal here, that order changed exclusive use and possession to title in as to both properties, as to paragraphs Roman numeral 3, paragraph 2 and 3. Correct? I mean, it did.
That is correct.
Okay. All right. So nothing further, Mr. Townsend?
No, I'm done, Your Honor.
Okay. Sometimes that's the greater part of valor, as they say. Okay. Ms. Liner, to rebut.
What is so important for everyone to understand, though, is the timeline on this. And so we're clear, it wasn't a motion to amend. It wasn't a motion to correct Scrivener error. It was literally entitled a motion to modify.
But the title of the motion doesn't control. It's good. There's a lot of law that says that it's the substance of the pleading or motion that controls its nature.
And importantly for the court to consider, Mr. Townsend's motion did not seek to do anything with regard to the Bullfrog property. He sought to modify solely, and again, if the intent of everyone had been for the Sykes Road property to be deemed as Mr. Martin's sole parcel, has his non-marital parcel, Mr. Martin's motion didn't seek to do that. It didn't seek to say, wait, court, you got this wrong. It ultimately didn't seek the relief that was ultimately ordered. But more importantly, then I go back to, we file a motion to modify. We have the appellee had all the time in the world to file a properly timed motion for rehearing, to seek to vacate within a year. If the court got it wrong and deemed and distributed to him as equitable distribution his non-marital parcel, but he didn't seek to do that. He waited until more than a year after the judgment became final. And it's not a simple Scrivener's error. That's, I think, the important thing that, if nothing else, for this court to consider of what really is a clerical error, what is a Scrivener's error.
And I
But
guess that's the bottom line, Ms. Liner, that if we come to the conclusion that this was a Scrivener's error or an omission or a mistake, you'd agree that there's really no timeline under the family rule. You'd agree with that, correct?
I would agree that there is no set timeline because it's basically a reasonable standard is what would be equitable. But the issue in this case,
Ms. Liner,
and
you have a tough spot that you're in. It's very unusual to have the judge who entered the judgment under oath and say, this is what I meant. I mean, how do you combat that?
well, if nothing else, the court can clear.
The family law judge said, I made a mistake. I'm here to correct it. I don't know I don't know what you do with that other than say, tip your hat and move on.
Well, I think part of the thing, is you all are clearly aware, is that she was not a fan of my client.
Yeah,
The original judge was not a fan. And so for her to say, yeah, I'm not going to do this thing that's going to help this lady that I clearly didn't like, even though she says she doesn't remember the parties independently. So
Well, I was a family law judge, as was Judge Kuzan for a while, and you don't remember names necessarily. And Judge Northcutt had probably as much experience as both of us together in family law. But once you start talking about the facts of the case, it comes right back to you in all its splendor.
but I think that's the important thing too, because regardless, the court, it couldn't have just been an error, because one thing that nobody talks about wasn't part of this motion, but there was, independent of the trailer, there was a whole other piece of real estate that wasn't distributed by this judgment. Now, there are some practical reasons why we didn't move to address it, but ultimately, there was lots of things that if they had been Judge Wilhite's intent to correct and she desired to correct, she had ample opportunity.
sure.
And she chose not to. And Judge Fuson, who was the judge who addressed the motion to vacate prior to Judge Moody taking the division, he instead denied the motion to vacate, the timely filed motion to vacate the judgment on these issues, these failure to distribute issues, basically because his position was the properties were held. They were now tenants in common, and they were distributed how they needed to be. Because if that issue had never been raised or a subsequent judgment, ultimately, and I believe that is what truly did trigger the appellee's much later in time motion to modify, is he realized he couldn't do anything with property without his former wife's consent, because they did join an oath.
Okay, your time is up, Ms. Liner. Thank you both very much.
Very much.
Thank you.
In order to leave our courtroom, you click the leave button that is on the Zoom screen